I'm saying all these people, and when I hire people, I mean, I enjoy what you're saying in here, but when I hire people, and I hire people all the time, and I interview people and blah, 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 and I hire them solely on who I think is the best candidate for that job, and some of these things are tangible, and I guess some are introspective, and it doesn't always work out right, and sometimes you have to go back and go to candidate 2 or 3.
Yeah.
But somebody could make the case that it's discriminatory for some manner, and I mean, everything is discriminatory. When you go to apply to college, they discriminate based on your grades.
And that's a legitimate...
I don't know if they discriminate on race or what other things, but I mean, it is what it is.
You've made an excellent point. There are lawful means of discrimination and there are unlawful means of discrimination. And it is very lawful to discriminate on the basis of somebody's college grades.
If I had a product to sell, whatever marketplace I deem to go after, I would put the best salespeople in that position. If they happen to be all black or all white or all women or whatever, let it be. But my goal, what I'm looking for at the end of my introspective or my tangibles with that candidate is who's going to sell the most stuff.
Well, you just made 2 different statements.
Well,
one of them is, I'm going to put my best salespeople in there, which is perfect. The other statement was, my goal is whoever I sent there is going to be the best salesperson. And I see that as...
The person who sells the most stuff is the best salesperson.
No, I understand that. But in the first statement, you're relying on experience that you've already had with that salesperson, saying, you're the best salesperson, I'm sending you to this market because it's a difficult market. Okay? If you say to somebody, you look like the people in the market that I'm trying to reach, you may be a lousy salesperson, but I think you're going to do great there. Okay, that's where you're in trouble, because then you're stereotyping the ability of this person to improve his sales or her sales in a market just based on what he or she looks like. And then that's where you could find yourself in trouble. The first half where you said, this guy's a great or this woman's a great salesperson, so I know that they're going to do great in any market, fine, go put them there. But if you do it prospectively and where you're speculating that I think you're going to do better over here because you look like everybody that we're going to put you in the middle of, I've actually seen a lot of people in my career fail when a decision like that was made because the person wasn't qualified, wasn't experienced, and the decision was made, well, we're going to try to make you successful because you have the right looks about you. And that can get you in trouble. Now, when you talk about is this person the right fit? Is this person, what's my feel, my gut reaction? That's okay. But what you need to try to do is see if you can quantify that gut reaction. What is it that's making me feel this way? Is this person gregarious? Does the person stutter too much? Which obviously might be a bit of a disability issue, so I shouldn't have used that as an example. But are they easy to converse with me? Those are all very objective factors. So even though you're getting a good gut feeling, it's probably based on something more objective. And it would be helpful to you to kind of make sure that you quantify what those are. All right, and then back to the NBA issue. There is an exception to discrimination, and it's called bona fide occupational qualification. If a business can establish that it must have a particular type of person in a particular type of position, then it is okay to make that discriminatory decision. So the question I always put to the audience is the Pope Catholic? Okay? You would never put a Jewish person in the position of Pope. Okay?
You have to pay him overtime?
Yeah, that's right. You have to pay them overtime. That's right. Good point. Maybe I'm wrong on that. So can anybody give me some examples real quickly before we wrap up of can you think of any jobs where there might be a BFOQ, a bona fide occupational qualification? We must have somebody of a particular...
Being able to carry a certain amount of weight?
Sure, that would be a physical requirement. That's good. Sure, Dune? Broadway, excellent. Yep, you have to have certain types of actors or actresses. A Rockette, prison guards. Okay, you're only going to have males guard the male prison cells, the women guard the women prison cells, those kind of things. So, but think about how much that has changed over the years. Who saw the movie Catch Me If You Can? Okay, right. So back in the 60s and 70s, flight attendants or stewardesses at the time couldn't be male, couldn't be married, couldn't be pregnant, had to be a certain weight, etc. And the fact is that none of those were bona fide occupational qualifications.
Wasn't it UPS that all the delivery guys had to have mustaches or something?
I don't know that one. Don't know that one.
That's the Red Sox with beer.
So,
What, was Disney sued or not, I think because of what they made them wear? Because they were required to wear their, like, you know.
there may have been a claim about that. It sounds vaguely familiar. So let me go to the last slide, because it's that time. The number one misconception, employment at will means that you can fire anybody for any reason you want to. Okay, I hope by now, through having sat through this session for 55 minutes, you know that this is a misconception. There are so many laws and so many exceptions to your being able to willy-nilly let somebody go that the concept of employment at will has been whittled down to a very, very small concept in the entire overall relationship between you and your employees. One second, let me just finish my thought process here. So when there are restrictions on the basis of discrimination. You can't let somebody go on the basis of a protected characteristic, age, race, sex, national origin, citizenship, etc. You can't let somebody go in retaliation for having brought a complaint against you, or filed for workers' compensation, or taking a leave of absence under the Family Medical Leave Act or some other protected behavior that they've engaged in. And of course, as I said, if you have a contract with them, that may limit your ability to terminate that employment. So I always tell people, don't rely on this as being your only employment law rule in the workplace, because it's not always going to be there to protect you. You've always got to make sure that you set your expectations with your employees, you communicate those expectations in writing if you can, you address behavior as soon as wrongful behavior, misconduct, or low performance as soon as possible. You set expectations again, and when it gets to the point where something bad might happen, you better set consequences. If you do not do X, Y, Z in ABC amount of time, there will be more consequences, whether it is further discipline or you will be terminated. I call that the magic words. You've always got to make sure that those words get in front of your employees, because that's when you mean business. And then make sure that they receive that in writing, that they acknowledge it, even if they don't agree with it, they still know that they got the message from you, and that will protect you in making decisions with your employees. And we had one more question from Norm. Sorry to.
It's got to be a quick one.
So if you get terminated and you think you have a reason for legal action, and you tell them that, and then they offer to pay you, like a severance or whatever, then you sign the piece of paperwork. Does that exempt you from, essentially ever filing anything against them again? Sort of that they're admitting that they did something wrong?
Yes and no. It depends on the language of that contract, and that it's called a separation agreement, or a agreement in general, release of claims. So you're basically settling a claim with that person at that time and paying them, and in exchange for that extra payment, the person is agreeing not to bring a claim against you. That being said, when it comes to wage and hour, that is a claim that cannot be waived. So a person can always bring a claim against you. The best way to protect yourself with a wage claim is to get an acknowledgement that they've been fully paid. That doesn't necessarily mean that there won't be a lawsuit, but it does mean that in the course of defending yourself, you can produce that evidence to say this person agreed that he or she has been fully paid for all the work that they performed for me. So there are some exceptions, but generally speaking, those releases are pretty solid. All right, I think we have reached the end of our presentation. How's that?
All right, perfect.
Okay, thank you very much, everybody, for your time and attention.
Kirsten, I want to thank you. Just so everybody knows, she has handouts up here, cards, and I'm sure she's going to hang out for a bit if anybody had any other questions they might not have wanted to ask publicly.
Yeah.
And we'll see you next month for Carl Gould. Thank you.